All right, everybody. Welcome to Transition Planning for Young Adults with Disabilities. This is Lisa Combs from the Ohio Association of County Boards, and I'm here with Ethan Welch from Hickman Lowder. We're excited to have everybody on and to hear more about benefits and transition planning for young adults. We have approximately 197 people in the crowd right now, and we're glad you're all here. And again, just really quick, there's the Q&A for formal content questions, and there is the webinar chat for introductions or chatting and commenting to us. All right, on that note, I'm going to turn it over to Ethan, and we're going to go ahead and get started.
Okay, great. Thanks,
All right.
Lisa. Well, like Lisa said, I'm from Hickman and Lowder in Cleveland, Ohio. We specialize in special needs planning and Medicaid planning for elder and our disabled population. With that, we do probate work, typical probate work, typical estate planning along with that. But our bread and butter is special needs planning and Medicaid planning. So with that being said, thank you for joining on a Friday morning. Hopefully this will be informative and won't bore you too much. And at least we have Friday to, it's the weekend. So just keep that in the back of your mind as we're going through this hour and a half talk about this transition planning. Transition planning, I think of, parents come to me when they're young child or they're, teenage child around 16 or so, 17 years old. And they say, well, our doctor or our school said that we need to, talk about guardianship. We need to talk about, what the next phase after high school will be. And that's when I talk to them about, well, there are options out there, and there's powers of attorney, there's guardianship. So let's talk about what you need, and it's a case by case basis. It's in one glove does not fit all. So it really is a talking point with the families, with the doctors, with the school to determine what works best. So this transition planning covers a wide area of vocational, educational, and then the legal aspect. The legal aspect is what I'm going to talk about today. What kind of benefits will be out there, and what kind of legal oversight that one needs over that disabled child. So with that being said, there we go. Buttons are working. Great. Here's the overview of the presentation. We'll be talking about guardianships and then the alternatives to guardianships. I'm going to talk as much as I can about government benefits, just so we all have a general understanding. And then the special needs estate planning part. The special needs estate planning is for planning to get this child qualified for benefits, and also, hey, I want to leave money aside for my disabled child. What tools are out there to accomplish that? So this is the overview of the presentation. And with that, let's get into guardianships. So, first things first, let's get used to the terms. And I understand that this was probably, you guys know this or you've heard of this, but I just want to emphasize, what these terms mean, because people confuse, especially our, people in our community. They just confuse these terms and they don't really, understand the grasp of it. So guardian. In Ohio, we say guardianship. The guardian is the person that's appointed by the probate court to oversee the ward. The ward is, the disabled individual that needs that oversight. Incompetence. Incompetence is a legal definition. It's a legal order from the probate court. basically this person has a mental impairment caused by a mental or physical ailment, a developmental delay, or chronic substance abuse. Further, that person, because of this incompetence, they are unable to care for themselves or their property, their money, and they can't meet legal obligations. Incompetency is often confused with capacity. So capacity, that's not determined by a probate court. Capacity, well, it can be determined, but capacity is determined usually by doctors, lawyers, social workers, people in the medical field to determine can this person make a legal or healthcare decision at that given time. And as we know, capacity can come and go. Think of people that are suffering from dementia. Dementia, in the morning or before lunchtime, you might not even think that they have an ailment. But then as you get closer to the evening, you have that sundowning where this person really is suffering from dementia. That capacity comes and goes. It can come and go by the hour, it can come and go by the week, it can come and go by the month. So capacity, different from incompetence. Incompetence is a legal order that this person cannot meet their legal obligations by the probate court. So why do we need a guardianship? So this family that's coming in, to see me, they might say, well, they're in high school. Their doctor said, well, you need a guardianship, that he's going to have this medical procedure and he can't sign on behalf of himself. So really, those are the reasons why they might come to me to plan for that transition planning, because at age 18, they're considered an adult. They can, in the law's eyes, they can make those legal decisions unless they're unable to by incompetency. So if they have money, we need a guardianship to manage those funds and that property. Placement is for where this person's going to live. A guardianship has that say to say he's going to live with me, he's going to live with a family member or a facility like an ICF, an intermediate care facility, or even a group home. The guardian has the say of where this person's going to live. And programming, getting involved in organizations. Those organizations will be able to speak to the guardian on behalf of the ward. So types of guardianship. So in Ohio recognizes these guardians, these guardianships. Obviously, natural guardian, that is, from age 0 to 17, the parent is the natural guardian over that child. They can make legal decisions on behalf of that minor child. If that person becomes 18, that parent needs to apply to be guardian of person, and guardian of person is the guardian that makes the healthcare decisions, placement decisions, and the education decisions over that ward. If the ward has more than $25,000, then a guardian of the estate can be established to oversee those funds. So, you might say, well, what if there's only $24,000? Well, technically, you don't need a guardian of the estate, but reality-wise and practically speaking, you might still need that because, the bank might require that. Even the court might require that. But that's the threshold amount. It's usually, if it's more than $25,000, then you definitely need a guardian of the estate. These other three, these are less common. A limited guardian is for a specific purpose. Sometimes I apply to become the limited guardian of the estate in order to do something, get rid of money, or, pay an expense, or I'm going to be the limited guardian to establish and fund a special needs trust. So it's only for a limited purpose. Sometimes when you apply to become the limited guardian, the court will say, no, I know you're applying to become the limited guardian, but we're going to establish a full guardianship. So even though you're asking to be for a limited purpose, the court might still say, no, you need to be the full guardian. And the same thing for the interim guardian. That's for a specific time period. Sometimes you just need to be a limited guardian because this person is, unconscious, in a coma. Well, once again, the court might say, well, if the person never comes out of it, then we can address it at that time. We're going to establish you as the full guardian, and then we can revisit that to determine whether a guardianship is really necessary. Then we have the emergency guardian. So emergency guardianships are very, very limited. It's for the specific purpose of, is this person, what I've heard from hospitals, from social workers, from doctors in the hospitals is this person dying? Is this person bleeding out? Is this person, without a medical procedure, is this person going to die? That is really the only, real reason to having an emergency guardianship be established, because an emergency guardianship is very different from a typical guardianship. There is no, there's a ex parte hearing, meaning that the ward is not present at the hearing. So the emergency guardianship can be established without the ward even knowing about the guardianship. So the court takes that with, they don't like doing it. They want to make sure that everyone's rights are heard, and, an emergency is not, yeah, he's in the hospital and he has a broken leg and he doesn't want to get the treatment. That's not a true emergency according to the Ohio Revised Code. So if a family says, no, it's an emergency, it probably is. I know it is to them, but in the doctor's eyes, in the court's eyes, it most likely isn't. So this guardian, who is this guardian, and who can be the guardian? Well, obviously the person has to be over 18 and has to be competent. That's check those off the box first. A ward can't be the guardian over another ward, obviously. The guardian of the person, many people don't realize that a guardian of person, there is no residency requirement in the state of Ohio to become guardian of the person. So I have many clients that, they became guardians over their siblings, and here in Ohio, and they live in Florida, they live in California, and that's perfectly okay. You can become the guardian of person over that ward that lives in Ohio. However, the guardian of the estate, that's a different story. Guardian of the estate, you're handling this person's money. The court wants to make sure that if the guardian of the estate, runs off with money, they can sue that person. And the court can only do that if the person is a resident in Ohio. It becomes increasingly difficult to cross state lines to sue someone. So the residency requirement is usually mandatory, unless it's named in a document like a will, power of attorney, or a notarized statement. I have a question that popped up here. Is there a recommendation for individuals who need a guardian but whose parents are not legal U.S. residents? So are you saying, let me clarify this, Tara. So the ward's parents or the alleged ward's parents are not legal U.S. residents. Is that right? Okay. So there is no, as long as they're residents in Ohio, there's no requirement that they have to be a legal, they have to be a legal U.S. citizen, of course, or a legal resident. Are you saying like they came, they're undocumented? Is that what you mean, Tara? Okay, all right. So an undocumented, resident, I'm just trying to, make sure I have the facts here. Undocumented resident, their child is disabled. They need to be guardian over that child. To become guardian, you have to get fingerprinted. Most county courts require a fingerprint, background check. So that person cannot, really can't be that guardian because of that legal status. So it would have to be a family member or a close friend that is a legal resident. Unfortunately, the court can understand that. In my my experience with with Cuyahoga County and the surrounding counties around here, I mean, they really want to make sure that the ward is being cared for. They don't, they're not going to go out of their way to get these parents in trouble. And for that reason, I feel like if someone else is applying to become this guardian, that can be worked out with the court of why that person is applying and not the parents. I think but that's an extremely tough set of facts. Obviously, you want the parent to become be that guardian because for obvious reasons.
Ethan, can I stop just about that a little bit more, and just so everybody knows, we will be having another session with another attorney specifically around guardianship. Probably, I think I don't know. Anyway, so it's a great question, Tara, and I've heard it come up. Is the same situation if there's a lot of alternatives to guardianship. I think what I've been hearing lately is that a lot of people, maybe you don't, could they do still like power of attorney or those kind of things with it being undocumented, or is that going to be the same kind of situation?
No, yeah, I mean, that would be a completely different situation.
Okay.
And, that's, so if that person's able to sign a power of attorney, then absolutely. That's what I'm going to suggest.
Yeah.
At the conclusion of, this
Sorry.
talk. No, that's fine. Because that's, obviously what I'm talking about, it's a lot to do, and it's a big deal getting someone to be considered incompetent. The court doesn't take that lightly, and no one should take that lightly. So if there's alternatives to the guardianship and they're able to do those alternatives, then that's the way to do it. So this guardian, then, if we're talking about the person that wants to be guardian of the estate, they have to be bonded by an insurance company. So what that means is they have to have an insurance policy over them to handle this money. And that is double the amount of the personal property, what that policy is. So if they're handling $50,000 of the ward's money, the policy should be for $100,000. $100,000 policy is typically around $400 $400 to $500 of a premium every year. So once again, the court wants to make sure that this person's not going to steal money, and if they do steal money, the insurance company will reimburse the guardianship of the guardian's bad acts. So that means that this is guardian of the estate. They have to live in Ohio, and they have to have a good credit history, and they can't have any offenses of theft or anything with fraud on their background check. They have to be bondable. And generally, an agency can't be the guardian. It's typically a person. So a company, for example, can't be the guardian over people. It has to be the person who works for the company, but the individual is the guardian. So like, I'm guardian of a couple of clients. It's not Hickman and Lowder that's the guardian. It's me as the guardian. So obviously they can't be charged with these offenses as well. So nomination of guardian, a parent may, appoint a guardian of a minor in a will. They can nominate. The court is the one that ultimately appoints the person. If the person is an adult who is incompetent, it can be in a written designation, like in a power of attorney. A parent can, in their power of attorney, say, hey, if something happens to me, I want this person to be guardian over my child. Or it can be in a standalone document. But a nomination in a will is not sufficient for an adult who is incompetent. So just another reiteration here that the court may appoint if nominated, and that's may. The court is not required to. In a nomination document, the court takes great weight to that evidence in a hearing that says, oh, a parent said they want this person to be the next, guardian. So why is that? They're going to dive into that. But they're not required to appoint that person because the court has the ultimate say of, who's going to become this next guardian. So the court procedure here of, we've come to the determination that this child needs a guardianship. So the application is actually really simple. It's actually, very easy to follow if you know these terms, of course. If you just look at this form for the first time, obviously it looks like gobbledygook, but it's a 2-page form application. It says who the ward is, the alleged ward, and who you are, and what your relationship is, and why you're asking to become the guardian. With that form, there's also the next of kin form. So that lists who the closest living relatives to that ward is, including the applicant, if the applicant is, the next of kin. So you list, if there's a spouse, you list the spouse, the children, the parents, the siblings, in that order. I've got a question here from Carissa. Can the ward cover the cost of the guardianship fee and the insurance fee for the guardian of the estate? Yes, that is typically how it's paid, is through the ward's funds. It doesn't matter who pays for it, but typically it's from that money that is the ward's. The reason why we have this next of kin form is other family who have priority or equal priority have the right to file a competing application. So if we're talking about siblings and the siblings don't get along, then one sibling applies and the other person of the other sibling can file a competing application, and those obviously get messy. but that's why you want to make sure that this person's rights are afforded and that the family members know what's all going on. I've got another question here. If it should be a person, how does it work with APSI as guardian? So that's the exception. That's one one of the exceptions, that it's typically just a person, unless it's a government organization like APSI or a semi-government. Court procedure. You file the application, and I forgot to mention, with that application, you file the statement of expert evaluation with from the doctor, and it has to be either a medical doctor or a clinical psychologist. Those they're the ones that actually sign off on it. Of course, it could be a nurse practitioner or a social worker that fills out the form, but the doctor or clinical psychologist actually has to sign off on the very end that yes, this is my document. But I've come to realize that is one of the hardest things to get as part of this application, is the doctor's form, because you need that to file, and it has to be the original. So some doctors are great with it. Other doctors, they do the form and they send over a fax, or they send over a copy, and even though we tell them 100 times we need the original to file with the court. But if that's the worst of the problems with filing this guardianship, then that's great. But that seems to be the sticking point for a lot of clients, is getting that original C from the doctor. So we file the paperwork. We file the next of kin, the application, the statement of expert evaluation. Typically, the court will set a hearing, 4 to 6 weeks in advance then. So a month later, the hearing will be set. During that time period, a court investigator will come out to visit with the ward and the guardian. The court investigator will explain the rights of the ward and explain what the hearing is, and this has to happen at least 7 days prior to the hearing. So what are these rights of the potential ward? Well, if they are contesting it, then they can ask for an attorney. And if they can't afford one, then one can be afforded to them by the court. They can ask for an independent expert evaluation from another doctor. They can have family and friends present. They can present evidence. They can cross-examine, and if they don't like the decision of the court, they can ask for the transcript so they can appeal. And that could be at the court's expense as well if they're indigent. So what are these, obviously, what do these rights remind you of? And, they sound a lot like, Miranda rights, and they sound a lot like rights afforded to, criminals in a criminal court. And that's exactly what, exactly right. Because what this hearing is, this is a trial. This is one side trying to, relinquish the rights of another side. And that's a huge, huge deal. And obviously, we understand, from, recent history, we see, the Britney Spears case, obviously. That's the recent one out of California, where Britney's rights were extinguished, and she didn't have control over her money and her healthcare decisions for, was it over a decade or so? It was somewhere around there. But that's when that occurred. There was a trial to determine, hey, is Britney Spears incompetent enough that she can't handle her affairs, her financial affairs, her medical affairs. In order to do that, the guardian must prove, all these evidence or all these elements. Is it is this person incompetent? Is there a need for a guardian because this person can't manage their affairs? And is there a less restrictive alternative? And typically, when we're talking about a transition planning for a child that's going to be age 18, and we know that this person can't sign a power of attorney, then these elements are proven pretty easily. When we don't know, and we don't know if we can prove all these elements, that's when we get into the mental health area, where we don't know if this person has capacity or is just completely incompetent. So there's a lot of gray area in those sorts of cases. So if the court determines, yeah, we meet all these elements, this guardian is suitable, if we take all of the evidence, is it clear and convincing that this person needs a guardian? So, what's this clear and convincing? What does that mean? So I like this table, because it reminds me of law school. Clear and convincing is somewhere in between, beyond reasonable doubt and preponderance of the evidence. So, there's not, is it more than likely that this person, needs a guardian? That's what that means. So beyond reasonable doubt, we've heard of that. That's in criminal cases. Has this person committed this crime beyond reasonable doubt? If yes, then you're sure that this person created this crime. Preponderance of the evidence, that's more of a civil case where a person was hit by a car and they got injured, so they're suing the driver. Is the preponderance of the evidence more than 50% likely that this person committed this act, this harm on me? So clear and convincing, we're somewhere in between that, where is it more taking all the evidence, does this person need a guardianship? You don't have to be 100% sure, but you've got to be more than 50% sure. And obviously things on the bottom there, that's where the police become involved, with, they suspect a crime. Do they have probable cause to, suspect a crime, to charge this person with a crime? That's a lesser threshold. Clear and convincing evidence is on the other end of the spectrum. Special considerations, let's say that this person does, they became a ward. There is a guardianship over them. Does that mean that all of their rights are gone? No, not at all. The ward can still vote if they're able in an election. They can still drive if they are, able to, if they're physically and mentally able to. They can get married, but you need court and guardianship approval. And the guardianship will terminate because at that point in time, if you become married, the spouse, there's that spousal relationship then that they have, they have that oversight then over that ward. So the guardianship of a person will terminate unless the other spouse is also incompetent. So there's special considerations to that. There's exceptions to that. Wills and estate planning, there is new rules out about estate planning in Ohio. You can do estate planning, but you need court approval. And to do estate planning, you need to basically have a hearing, have another trial with the family members to determine, is this estate planning reasonable? Does everyone agree to it? So obviously it's not, it can't be all on the ward to determine who they want to give money and property to. It has to be a group effort to determine that. So obviously, voting and driver's license, that can be revoked by the court by a court order. But initially, there is nothing preventing them from doing those things. So the guardian has been appointed, and what's the oversight? What's the reviews of these guardianships then? Well, every 2 years or every year, it depends on the local rules. You have to file forms. So wait, I got a question before I move on. Sorry. If guardianship ends when someone gets married, how does that work inversely? If a married person is appointed a guardian later in life, is the ward still considered married? No, the marriage is not dissolved. It's the marriage is still active, but you have a court determination that at that point in time, the spouse can't be the guardian, and someone else is appointed a guardian. So you see that all the time with, elderly clients, elderly population, where maybe both of them, or both of them are suffering from dementia, and the children apply to become the guardian. Well, they're still married, of course, but now the children has that oversight and the court oversight as a guardian over their parent. So it doesn't dissolve the marriage. It's only if there is a guardianship and then they get married. That's when, obviously that's pretty rare. But that's the wrinkle in the rule. And obviously the court has to, the court might say, no, we're not going to, you can get married, but we're not going to relinquish the guard and terminate the guardianship. But it's an option. So every year, every 2 years. Did you say that another question came up? Did you say that a spouse cannot become a guardian? No, I said that if the spouse has the first priority to become the guardian, and usually the court will always have the spouse be the guardian. But if that spouse is also incompetent or doesn't have the capacity, then they won't appoint that spouse to become the guardian. So this appointment reviews, you have to file paperwork with the court, every year or every 2 years, depending on the local rules. It's a guardian's report and a guardian's plan and a new statement of expert evaluation. The court wants to make sure that this person still is incompetent from the medical perspective. The ward can request a review every year. You can, or more frequently, you can do a motion to review. That depends on the local rules. Some counties say every 6 months, or every 90 days, that you can request a review. But here's another thing that many families and individuals don't know about is complaints to the court. They can file a written complaint or comment to the court, and that can be from the ward or anyone. It could be from a family member, it can be from a close friend, that they don't like what the guardian's doing, or the guardian's being neglectful of his or her duties, and they want the court to know about that. So they file something with the court, this complaint, and most counties have a form that you can get from their website and print off and type in. But this complaint will address the concerns to the court, and the court might set a hearing on that complaint to determine, well, guardian, are you doing the right job here? If not, then you have some explaining to do. Always remember that the court is the superior guardian. It kind of segues to that complaint scenario, where if the court doesn't like what the guardian's doing, then they can be removed and replaced. The court can always override what the guardian is doing, because the guardian is simply the extension of the court. It's their feet on the ground for the court to oversee this disabled individual. Well, how do we make sure that the ward is, or the guardian is, doing a good job? Well, they have these duties that they have to do and perform. So I got another question that popped up. If there is a risk of declining health of the guardian in a situation where the spouse is a guardian of their spouse, can they be declared unfit to care for them before the situation becomes a crisis? Absolutely, and that's what the reviews are for. That you want to make sure that the ward is being cared for, and so if someone thinks that the guardian isn't up to that task, then they can ask for a review, and they can apply to become the guardian. So that's always a possibility. So like I said, the court is the superior guardian. They want to make sure that the ward is being properly cared for. So obviously we've got all the reports that they have to fill out. They have to act in the best interest of the ward. The mandated training of guardians. So the Supreme Court this is what the Supreme Court has said about training, that you have to follow these rules unless the local rule, the court has specific rules that you have to follow about training and education. So the default rules are, once you're appointed guardian, you have 6 months to take a 6-hour training course that could be either in person or through the Ohio Supreme Court website. And it doesn't have to all be done at the same time. It can be done over time. But after that 6-hour course has been completed, you got a certificate, you submit that to the court. And then every year thereafter, you have a 3-hour training. Some courts, I know in Cuyahoga County, they waive that training if the guardian is a family member of the ward. But most courts require this training. If you or the ward move, you have to notify the court. But it's only if you have to notify the court, or you have to get court permission to move if it's more restrictive. So if you're going from your home to the group home, well, you have to get you have to notify the court and get written permission from the court technically in order to do that. Got another question here. Can you talk a little bit more about how to address issues in which a ward is asking to do something that the guardian doesn't want them to do? For example, a ward wants to attend an adult day program, but the guardian doesn't want them to when there's no risk to health and safety. So the ward does have rights, and the ward doesn't have to do anything or everything that the guardian has to say. For example, you can get this ward into a group home, but that doesn't mean that the ward has to stay in that group home. The ward can leave, and go live in the street. You can't really force this ward to live there. Vice versa, then, on the other end, what you're talking about is the ward wants to do something, but the guardian says, no, you're not going to do that, like this adult day program. Technically, the adult day program and the provider at the group home or what have you has to follow what the guardian is saying. If that is for no good reason, that's where this complaint process with the court, that's where that comes into play, where you notify the court of, listen, we're trying to get good programs and good education and just we're entertainment for that matter for the ward, but the guardian is refusing that, and we want to hear from the guardian why he or she's not doing that and explain that to the court. That's where you need to use this complaint process with the court to explain to the court, hey, the guardian's not doing a great job here. There could be great programs and avenues to take to benefit the ward, and they're just not doing it. I've got another question here. If a person has a guardian and co-guardian, do both guardians have to agree on things, or can one guardian override the other guardian? So that's a great question, and this is why most courts do not like having co-guardians, because yes, they do have to agree, and it puts healthcare providers and other programming agencies in a bind if guardians do not agree. And that's why most courts say no, we can't do co-guardians. They might have an exception to that, to say that if there is a co-guardian, then it has to be a married couple and over their adult child. That's the only reason. That's the only way that some courts allow for a co-guardian. But
Sorry, Ethan, I was going to interrupt you, but I didn't mean to.
No, that's all right. Go ahead, Lisa. Go ahead.
I was just going to let people know, as far as the specific scenarios with the guardians, I understand this is the SSA world. Kelly, your comment and question is amazing. But I know that Ethan has a ton of stuff to get to that's outside of the guardianship realm too. And we are going to have more training specifically around some of these grayer areas with guardianship. Maybe Ethan will join us in the future for some of those too. I would love to have a panelist of people because we have so many. But yeah, this is, and Ethan is one of our newer presenters about guardianship, but this is exactly the stuff that comes up every day, Ethan, for SSAs across the state, about trying to have guardians, especially who are family members, kind of balance that idea of risk and doing things outside the norm. So I'm going to save your questions because they're amazing. But Ethan, you're more than welcome to answer them. But I also think in order for you to get to all the stuff you wanted to, I want you to be able to.
No, one thing that I know that a lot of essays and I have a social worker and that works for my office as well. One thing that really comes up is diet and food choices of the ward. And that's a huge gray area where they want to eat fast food and junk, and they're diabetic. The ward is diabetic, and the provider is saying, well, we're going by what the ward wants, and because they have this food choice. Well, if you have a medical opinion that they shouldn't eat this, they should eat more healthy foods because of a medical reason, then what's right and what's wrong. And I'm at a point where I do have a client like that maybe we just need to get a court order. There's a lot of, like what you said, Lisa, there's a lot of gray area, and maybe the court just needs to get more involved and to determine these rights of the ward. And
And I think the biggest answer a lot of times is the stuff that guardians, when you are struggling, you can't really control, no matter you're a guardian or not, you can't really control.
Exactly.
We're not going to rip food out of people's hands and mouths because it's, bad for their diet, or even if they're allergic. I mean, you can't physically,
Yeah, you can't
so
throw
it's
them in a room and throw away the food,
It's like taking meds is the other big one that we get all the stories about. Like, you have to make him take his meds. It's like, no, we can't do that. So
Yeah.
it is a huge issue, especially in Ohio, because we have some pretty rigorous rights restrictions rules within the DODD system. And so it's a constant struggle, but I love these questions. I'm going to save them for when we were putting together a 2024 session around these kind of really tough gray areas and what are some strategies to deal with that. So I love
Sounds
it.
like it would be good for like a panel, Lisa.
Yes, exactly. I like that.
Throwing that out there.
Yeah, thanks.
So we talked about complaints. Obviously they have a duty to report abuse and neglect, like most medical professionals do and social workers do. Then the representative payee for Social Security, the guardian of person can apply to become the representative payee. You don't have to be the guardian of a state to be the rep payee. And the Social Security income is not reported to the court since the Social Security Administration administers that program. That's most courts. Some courts might still require that. I hope not. But I haven't seen a court recently require reporting Social Security as part of their accounting. Conflicts of interest, generally we want to avoid it unless it's approved by the court. The caregiving component, that was before the pandemic. The pandemic really widened this birth of, this can Medicaid pay the guardian for caregiving, especially if you're thinking of like the parent over a severely disabled, adult child. Now the Medicaid will allow that as long as you have something written by the court allowing that, an order saying yes, the parent can be paid as a Medicaid provider.
And I'm going to head off a question about this topic. It's super important to know that as SSAs, it's not our responsibility to confirm that, but it is our responsibility to make sure that the guardians who are operating as providers, that you have let them know of that it's their responsibility to go back to the probate court and get permission. And document that you've done that. And then at that point, it really is between the guardian and the probate court. There's only so much we can do. Having said that, if a guardian is providing direct support through the FMS, the financial management system, our current financial management system does require a copy of that paperwork. There you will have probably it's an opportunity at that point to get a copy of it for the county board to have on file at that time also, but it really, again, is between the guardian and the probate court. There's a question in there, can guardians of minors become their paid provider? Elizabeth, you just hit on the hottest topic in Ohio right now. I don't know how much Ethan knows about that. It is currently in rule. Right. It's been an Appendix K flexibility, and it will be in rule as of January 1. And the any details about that would be another hour-and-a-half session. So happy to talk about it, but probably there will be a future where that is happening, I think. So, and they're not guardians of minors per se; they're parents of minors.
Right.
So, which is a guardian.
Yep, natural guardian. Yeah, we hit that term. I'll give the attorney answer. It depends on that. Yeah. People love hearing that. Then, so we're almost wrapping up with the guardianship report. So I'll hit these last few slides pretty quickly. termination or removal of guardian. Obviously, if the ward is no longer incompetent, it's got to be proven by a doctor through a CE or evaluation. It can be terminated. The guardianship can be terminated. I always tell clients guardianship is semi-permanent, because you always have that. Obviously, if the ward is has a diagnosis that there's no it can't be reversed. Obviously, that's not the case, but there is a theoretical chance that a doctor might say that this person is competent, that they no longer need a guardian. I've done that before.
Yeah, I think there's more restorations going on than we've seen in a long time. So and I think it is, and different doctors have different opinions. So sometimes when people get new doctors, they might have a different opinion or whatever. So I love the idea of thinking about if restoration makes sense.
If a guardian resigns, that doesn't mean the guardianship will terminate. That just means that the court will appoint a new guardian. So if a family member is not going to step up, the court will reach out to an organization or maybe even an attorney to become the new guardian. And if a guardian is removed, if they think that the guardian is not doing a good job, they can be removed and replaced. But note that the removal is only in the best interest of the ward. So if the ward just doesn't like the guardian, but the ward is doing well, that's not a cause for removal. If the guardian is neglecting and not doing his duties, potentially that is a cause for removal. But obviously, with all this talk about guardianship, we understand that it's another piece of the government here. And having government, you have red tape, you have a lot of oversight. So we want to try to avoid guardianship. And we avoid guardianships with powers of attorney. And I know, speaking with many social workers and NSAs, that they are a lot of times are, sometimes they don't like that power of attorney because it gives that right to steal, especially for, clients that do have money, obviously, and they do have a big social security check coming in. It gives them the right to steal. But powers of attorney can be crafted and drafted to avoid that, that temptation on that agent under a power of attorney. In our powers of attorney, we have oversight provisions. We have consenting party provisions where people can be appointed to have a right to review documents, review bank statements, and in order to do certain things, maybe they put a dollar amount in there that they can spend. You have to have permission from this consenting party to do those acts. So a power of attorney is not just, one size fits all. It can be drafted however the circumstances see fit. And with a power of attorney can always be revoked. So these powers of attorney, we know this. It's a healthcare power of attorney. It's a durable general power of attorney. And I forgot to mention in here, for our clients going through a transition planning, we do a educational power of attorney. So the educational power of attorney, a lot of these clients are in school still up to age 22. So with an educational power of attorney, the parent can still sit in on IEP meetings and 504 plans with the school. So they can be that helpful tool for that disabled child. So and then we have the advanced directive for end-of-life care, the living will, and then the mental health directives. So obviously, with these powers of attorney, we have an issue with, they can be revoked. They can tell the doctor, they can tell the financial institution, yeah, don't talk to my parents. I don't want you to, and I want to do something else. I want to do this instead of this treatment plan. The doctor has to follow what that child is saying because they're not deemed incompetent by a probate court. There is no guardianship over this person. I really see that with our mental health clients. I don't really see that for our developmental delay clients, but I mean, it happens. Elizabeth has a question. Does the court have to be involved in appointing a POA, or does it have to go through a private attorney? A power of attorney is a private document, and there is no court involvement with a power of attorney. So you either have to go see an attorney. Most powers of attorney can be found online. I know the Ohio Bar Association has, basic powers of attorney, but that's exactly what those powers of attorney are. They're very basic, and you need to, craft the power of attorney to fit that person's, life. So you can use one off the internet, but you probably should, at least consult with an attorney before, going through with the power of attorney. I got another question here. With the guardian that resigns, so we're going back a couple slides. Sorry, but I missed this. Technically, they stay guardian until the probate court can appoint another, correct? Yes, that's what the court wants, that they can't, they want the person to still be the guardian until a new one's appointed. But it all depends on the circumstances. And if they put, in their reasoning why they have to resign, then, immediately the court might entertain that if, because they are the superior guardian. They can always, make decisions as the court on behalf of the ward if necessary. So here's the special issues with the POA. At that point in time, the only option really is to apply for guardian. If this adult child is not going along with this power of attorney, then, and they're refusing any help or treatment, then at that point in time, you can apply for guardianship. And, these kind of cases, it's a gray area, but the court will appreciate that. Okay, you tried the power of attorney and it didn't work for, these reasons. And the court will say, okay, you tried the least intrusive means, but now we have to do the guardian because it's what's needed. All right, so that's my guardianship talk. So we're going to jump into benefits real quick and, how to protect these benefits. So these are the big benefits that are available. Obviously, there's other ones with utility assistance and so forth. But Social Security, that's supplemental security income, Social Security disability insurance, and then just regular Social Security retirement. Then you have the insurance portion where we have Medicaid and Medicare, and then of course private insurance. Then we have the food stamps and TANF. We have HUD housing, and then we have of course the DD waivers that through the county DD boards. So I love this slide because it shows how related these benefits are with Social Security and the insurance portion, but also, they're different programs. So SSI is related to SSD. SSD is related to Medicare, and Medicaid is related to SSI. So people that are on SSI typically receive Medicaid. People that or on SSD typically receive Medicare. There are some clients that receive all four. So it all depends on what the what the case determines. But with this being said, all these names sound alike. They are confusing, and many clients don't know what they have. It's amazing that they've been on Medicare for 15 years and they thought they were on Medicaid. It happens all the time. So verification of documents is always important, because it matters. They think that they have to have under $2,000 in their account. Well, no, you're on SSD and Medicare. There is no asset requirement for those programs, and you've been doing that for 10 years and you didn't have to. So with that being said, supplemental security income and SSI and Medicaid, those are the programs that have the asset and the income requirements. These are the need-based programs, which basically say that you have to be medically disabled, and you have to be, poor. You have to have less than $2,000 in assets. Obviously, there's exceptions to that. With the Medicaid workers buy-in program, you can have up to over $14,000 in assets. But the baseline is you have to have less than $2,000 in assets, and your income must be low as well. For SSI, you can only receive $914 in income from SSI. You can still work when you're on SSI, but that will count against what you receive from SSI then. And obviously, we have deeming issues for minors. So deeming means that if a parent has income, if a parent has assets, those deem to the minor child. So that's why a lot of cases, a minor child is not going to receive SSI until they hit age 18, because parents' assets and income deemed to them. We have exempt resources. So I said, you have to have less than $2,000, but it can be, they can still own personal possessions. They can own a home. They can own a vehicle. They can have an irrevocable funeral contract. They can have life insurance policies, as long as the face value of all those policies are less than $2,000. So if they have a policy, the face value, the cash value is $1,500, that's exempt. And then obviously we have exempt trusts that we're going to talk about in stable accounts. These are the big exempt resources. There's other smaller ones, but these are definitely the biggest ones. Before I get into the trust, let me go back to this slide. I mentioned the workers buy-in program. There's also another Medicaid program. There's other Medicaid programs like SRS Medicaid, which the name is, escaping me right now. Supervised recovery services. Is that right, Lisa? Do you know?
That's a good question. You're asking me. I will tell you that if you go to the Employment First website, there's an entire if you search Employment First Ohio and Fear Factor, we have a ton of sessions about all the different programs.
Okay.
There's a really great group of people that have been doing trainings over the past 3 years about that. So
all right, perfect.
We don't have to know it all, Ethan. We just need to know where to find the information.
Yeah, exactly. You need to know where the information is. But I just wanted to mention, there's other Medicaid programs that don't have the traditional Medicaid eligibility, like the SRS. You can have as many assets as you want, and they don't have an asset requirement. Same with MAGI Medicaid, which is modified adjusted gross income. That looks just at the income of the individual. So you can have $1 million in the bank, but if you have no income, you can still qualify for Medicaid. There's no disability requirement for those for that program. So there's other Medicaid programs out there, but typically what we see in this environment with the in the DD world and the transition planning world, where they have to have less than $2,000 in assets and their income has to be substantially lower. I wanted to also mention about Social Security, that a child that is on SSI, especially with this transition planning, where a child is, they're not receiving SSI until they reach age 18. They qualify. For the next 10 years, they're on SSI. Because they were deemed disabled before the age of 22, they are now a disabled adult child under Social Security regulations. If a parent, starts receiving Social Security retirement based off of their work history, the child can now receive SSDI based off of their parents' work history because they were disabled before the age of 22. And that would be 50% of what the parent would receive. So here's the scenario. Parent retires, they receive $2,000 in Social Security retirement. The child now receives 50% of that as well, but in SSDI. And that, so they jump up from $914 in SSI to $1,000 in SSDI. After a 2-year probationary period on SSDI, you qualify for Medicare. So that slide right here, there is scenarios where the child can receive all 4 of these programs. And just because they now receive Medicare, the Medicare will be their primary and Medicaid will be their secondary. So they won't lose their Medicaid benefits. So that, that leaves with, some people retire earlier in order, they don't wait until age 67 to start receiving Social Security. They receive it at age 62 or 63 because they know that their child will receive, a big step up in money, and they don't have to have the reporting requirements of SSI. So I thought that's just worth mentioning to you guys. So to qualify for these needs-based programs, SSI and Medicaid, we use special needs estate planning, and that's mostly with trusts. So there's 2 categories of trusts, and it's either parent funded, third party funded, or child funded, or first party funded. So it's a third party trust or a first party trust. It only matters where the money is coming from. That's the first question. Where is this money coming from? That determines what kind of trust we need to create. Because if it's first party funded, this is a Medicaid payback trust. That's a special needs trust. That's what people hear, Medicaid payback. Because the government is saying, Ohio and the federal government, if this child who is on Medicaid receives an inheritance of $100,000, the government's saying, listen, we understand you receiving this money will kick you off your benefits. In order to prevent that from happening, because the benefits and Medicaid and your DD waiver, that's incredibly important. What you can do is you can put that money aside in a special needs trust or a Medicaid payback trust to retain your benefits. The caveat to that is the government is saying, if there's any money left over in that trust when you die, we get the first bite of the apple to get paid back for the Medicaid that we've given you throughout your lifetime. So the idea with the Medicaid payback trust is, yes, you use it for the disabled individual, the beneficiary, as much as you can, because, we don't want any money left over in that trust because it's going back to the state anyways. Typically this is where it comes from, inheritance, a litigation proceeds, from a personal injury case, child support in a divorce setting. So typically child support ends at age 18, but for a disabled individual that can be extended through their lifetime if they're considered a castle child under a divorce setting. And that income then is paid to the child after age 18, which could kick them off their benefits. So you need a special needs trust to put that money aside. And then we see this sometimes with Social Security back payments. They improperly calculated Social Security, and here's $30,000 over the last 10 years that you should have gotten. You can put that money in a special needs trust if you can't spend that within a 9-month period. The third-party trust, this is what we use for estate planning. So the third-party trust is a parent or any individual is setting aside money for the disabled child. The beauty of this trust is there is no Medicaid payback provision in this trust. So it works just the same as a special needs trust, but it doesn't have this Medicaid payback provision. But you might say, well, Ethan, why don't we use this trust all the time then? Well, it depends on where the money's coming from. So if the child has ownership, control, possession of this money, he cannot put this money in a third-party trust. It can only be in a first-party trust. So there's different scenarios of why a first-party trust and a third-party trust, matter and when to use them. So at the beneficiary's death, the remaining assets in the trust would be paid to family members, to charities, basically to whoever created this trust, whoever that grantor designated in the trust. So then we've got stable accounts. So stable accounts, when they first were enacted, I believe in 2014, 2015, they were initially thought to be used to, get rid of special needs trust. But that clearly hasn't been the case because there's a lot of restrictions on a stable account. The stable account has a Medicaid payback provision, just like a special needs trust, except it's to the point of opening the account and not to the point of birth. There's also a $17,000 annual contribution limit. So a person that receives a $50,000 inheritance, they can only put $17,000 to this trust or to this account. That contribution limit, that is total. So if a parent wants to put money aside in a stable account, and they put $5,000 in there, well, it's only $12,000 additional can be put in there from all sources. So it's a $17,000 contribution limit from all sources. If the person's employed, that person can contribute more money. Right now, that's $13,590 to the stable account. So obviously that makes sense. The government wants people working. That's why we have that Medicaid workers buy-in program, so they can have more money in their account, and they can contribute more money to a stable account. And they have a $100,000 maximum in the account before it starts counting against them for SSI and Medicaid purposes, and the lifetime contribution limit of $517,000. There's certain requirements to open up a stable account. And I forgot to mention this. The stable account is only opened online through the Ohio Secretary of Treasurer's office. And the website is www.stableaccount.com. And surprisingly, Ohio has one of the best stable accounts in the nation. So other residents from other states actually come to Ohio to open up an account, a stable account. And the reason for that is there's a lot of flexibility with the funds. There's also investment options that Ohio provides through, I believe it's Vanguard, where you can actually invest funds in a stable account, much like a 529 account with college. There's kind of like it, but something very similar to it. So to open up a stable account, you go to the website, you follow their prompts. It's actually pretty straightforward. They'll have a question. You have to be considered disabled under Social Security or proved like that standard. For some reason, you have to be disabled before the age of 26. It makes no sense. The only reasoning you can think of why they put that age requirement in there is it kind of matches what the health insurance requirement is for children. But it makes no sense. So if you are age 30, you get in a car accident, you were not disabled before the age of 26, so you can't open up a stable account. And you need to get on Medicaid. It's hopefully that rule will be changed, but there's nothing in the works now, unfortunately. So just like a special needs trust and just like every other account that a person owns, there's oversight over these accounts, these stable accounts through Social Security and Job and Family Services. So they want to make sure that this account is being used for the benefit of the beneficiary and not anyone else, and the money is being used appropriately. Ultimately, the stable account is a useful tool in the toolbox for family members and for disabled individuals. The great thing about stable accounts is you can use money in a stable account for food and shelter expenses. So, typically, if another person, like a parent, pays additional money for rent or gives money for food, that will disrupt SSI benefits. But if the parent just gives money in a stable account to supplement food and shelter expenses, the stable account is technically in the individual's name, and they can use that to pay for food and groceries and going out to restaurants and paying the additional money for rent if needed, above and beyond what SSI would allow for. So it's a wrinkle, it's an exception to the food and shelter in-kind support and maintenance rule. And that's why a lot of clients use stable accounts, especially for those SSI purposes. And finally, I just wanted to touch on these pooled trusts. So a pooled trust is, managed by a nonprofit organization. In Ohio, there's two organizations. There's one in Dayton, and there's one in Middleburg Heights in the Cleveland area, where the people can, if they don't have a trustee or someone managing this money for them, they can give this money to the nonprofit organization to manage for them. And the good thing about this is they handle millions of dollars worth of people's monies. They can pool the money together. They can invest it together. And as long as the stock market is doing okay, you can get a reasonable return on the investment. Where if you invest $20,000 in a special needs trust, well, that's pretty risky of investing only $20,000 into a brokerage account yourself. Where you pool your money together, you can invest it, pretty well. So this is just another avenue that people can take using a pooled trust. There is a lot of red tape dealing with a pooled trust. You're not going to get your money right then and there as you would if you had a special needs trust or a stable account. It might take a couple weeks for things to be paid and distributed out. But it's a good, it's a good tool, like I said, in the toolbox. I had a comment or question here. Is there a list of what is acceptable to buy with the stable account? The rule is very broad. And that is, there on the stable account website, they do have a list of items that you can, purchase it for. And it is very broad. And that's a good thing. I tell clients, as long as you're using the money to benefit the individual, the beneficiary, then that's perfectly acceptable. You can use it for entertainment expenses. You can use it for food and shelter, for medical expenses. You can use it to indirectly benefit the individual. So that means, like, you can use it to, if they need to pay a caregiver to go on a trip with them, then absolutely. If that person can't go on a trip without the caregiver, then they're not going to go on a trip. So as long as you can justify, yes, I'm using this money for the benefit of the beneficiary, it's an allowable expense. And that's why it's very broad for that reason. So I think that's it. I think that's it, Lisa.
Wow, Ethan, look at you. You're so good. It's 10:30. Wow. Well, so yeah, you did great. So thank you so much. And, I always say we should probably start with the benefit stuff, because we could talk about guardianship issues and alternatives to guardianship for the next 3 years and still not have the answers. So maybe we'll do that next time. But anyways, thank you so much. I did put a link in the chat box for that stable qualified expenses page that Ethan was just talking about. We appreciate everything. Again, just remember that you should be getting an email from OACB Member Connect to collect your CPDUs, probably next week, maybe Tuesday. If you have any problems, you can reach out to me directly or training@oacbdd.org. Oh my gosh, I just blanked out. And hopefully we will hear again from Ethan. We do have some other upcoming trainings coming up around, like I said, guardianship, and certainly probably more around benefits, because we never can have enough. So have a great day, everybody. Oh yeah, and hopefully there'll be a recording available. I don't think we did too bad. So, all right, we will see everybody and have a great weekend. Thanks so much, Ethan.
Thank you. Yep, no problem.
All right, I have to end the meeting and it just like, bam, cuts it off. So there we go. Oh, stop recording.